Greetings and salutations, everyone. Today we're talking with Eddie Craig by request. We have a lot of people out there, fans of Eddie over here, and we just wanted to get him on and hear what he has to say. Eddie, welcome.
Thank you for having me.
Yeah, absolutely. And so I think most of our people now, obviously, criminal is well, let's do criminal on the back end. Let's talk about traffic up front. What how do you go about doing all the traffic stuff, and what's your first steps? And
Well, the first step is we go to challenging the jurisdiction of the allegations to begin with, personal jurisdiction and subject matter. And there's two reasons for that. First off, once you actually study the transportation and administrative codes for the state of Texas, you find out very, very quickly that they are limited to a specific subclass of people within the state. They don't apply to everybody. They apply only to those that engage in a specific profession or occupation. And that profession or occupation has to relate to transportation. We know this because the Texas Constitution requires every bill in the state of Texas to be passed using a single subject as the umbrella for everything within that bill to fall under. So you can't put anything into a legislative bill that is unrelated to the subject matter that the bill title says it relates to. Well, the title that created the current existing form of the combined transportation statutes, which was SB 971, enacted by the Texas legislature in 1995, is a recodification of the previous version of statutes. They were scattered through several different codes. What they did was they collected them all together, titled them under the single subject of transportation, and combined them into a single unified code. Now that they're all collected in one place and that they're all defined under that one umbrella of transportation, everything in that code has to be relevant to the subject of transportation or it's unconstitutional. So the first challenge we make is, and which the courts have ignored thus far, and right now I'm making a separate argument about that, but I'll deal with that in a minute. But the first thing we do is challenge the application of the law as being unconstitutional because it is outside of the subject matter scope to which the legislation is limited. Well, the Third Court of Appeals here in Texas ruled in several consecutive cases titled Perkins v. State, where the same guy had multiple charges and multiple appearances before a court making the arguments that I've got laid out, though I can't say for sure since I never saw his original pleadings how well he made them. But the Third Court of Appeals, ignorant idiots as they are, and I know this for a fact because I've met each of these judges individually, personally, before they became Third Court of Appeals judges. And
obviously that's the state Court of Appeals, right?
Yes, the Third Court of Appeals in Austin. And the judges on that bench are complete idiots. They really, really are. In fact, one of the judges used to be a municipal judge, then she became a district judge, and then she got arrested for a DUI, and they played around with her DUI by delaying her breath test long enough for her to pass the test by 0.01 on the scale of 0.08. She blew a 0.078.
Gotta love friends in high places, huh?
Yeah. And so she got off a DUI literally by the skin of her teeth because they spent more than 3.5 hours before they administered the breath test. They knew what they were doing when they did that. But she is now a judge on the Third Court of Appeals, and she was one of those judges that signed off on this opinion in Perkins. And all the judges on the Third Court of Appeals declared that the word transportation is simply a title of the book that the code is called. When the bill itself says that these are statutes relating to the subject of transportation, the Third Court of Appeals completely ignored the bill and just said it's just a title in the book. Now, if that's not judicial incompetence, I don't know what else is.
Well, is it incompetence or intentional obfuscation?
Well, it's either judicial incompetence or judicial corruption.
Right.
And I've got a legal blog where I wrote an article where basically I said there's only 3 ways that you can view a court's bad opinion: reasonable error, reasonable error because of ignorance. Then you've got intentional ignorance, and then you've got corruption. But if you take and look at how the system is designed to function, all of them boil down to really just one, and that is corruption. You can take their ignorance and show very quickly how that ignorance itself becomes corruption, because a judge or a cop or any other public official that chooses to be ignorant of the law so they can continue to misconstrue it and misapply it are, in that sense, corrupt. And there's no way around that.
I would agree with you. We've seen it countless times for sure.
Yeah, but in any case, we go after those. We start there. I make the argument that they cannot separate the subject matter from the offense. When they file these criminal complaints in these cases, you never see in the charging instrument that while engaged in the business or occupation of transportation, the defendant did blah, blah, blah. Okay? The problem is that is the threshold element to any transportation-related offense. You cannot separate that threshold element from every other element of the offense. It is legally impossible to do that and maintain the single subject requirement of the Constitution. You just can't do it. But they never allege the person was engaged in transportation. They never look at any of that as being limited to a single subject. They just try to lump everything into one basket and apply it wholesale across the board to everybody.
Well, that's just easier.
It is easier. And I love it when a prosecutor goes in front of a jury in a court and says, well, Mr. Craig thinks the laws don't apply to him. Well, guess what? I don't think the laws applying to commercial fishing apply to me either, because I'm not in a boat catching fish and selling them on the open market. Now, are you going to try to convince the jury that I'm guilty of violating a commercial fishing statute when I go to the grocery store and buy salmon out of the damn freezer?
Well, they are fillets. They shouldn't be outside your home.
Yeah, well, that's the kind of common sense our prosecutors and judges completely lack. And so those are the kind of things that I go after on a regular basis here and teach people about. But I use black letter law in the Constitution for everything. If I can't support what I'm telling you with either the Constitution or black letter law with no more than one level of inference from the facts that those give us, then I don't tell you it's true. I tell you it's a theory, it's possible, but it would depend upon how far down the road you can carry that extrapolation. But the rule of thumb is you never go more than one level of inference from any given legal fact. And we don't do what the patronuts do and build inference upon inference upon inference till we have a house of cards instead of a house of bricks.
Right. So let me ask you, if you, when and if you're pulled over for quote unquote speeding or whatever, how do you handle the cop? You just take your ticket and walk away, or do you have a conversation with him?
I let him do his thing as much as possible. One of the things I tell my students is you don't hold court on the side of the road. Arguing with the cop on the side of the road is not only pointless, it's dangerous. Okay? Take him to court, fight him there. Preferably in one of record, but we don't always get that on the first go around.
Right. And then you got do you sign the ticket when asked?
There's nothing in the ticket that's an admission of anything by signing it.
Okay.
The ticket is your appeal or your appearance bond. That's all the signing of the citation is. Now, there's a problem with how they're doing it. A summons, from what I've learned in case law and study and all this, a summons is a judicially issued process. It is not an executive issued process.
Right.
And the cop is an executive officer. So constitutionally and legally speaking, the cop cannot issue a summons. Well, the legislature finally got that through their heads, and back in, I think it was 2015 or 2017, they amended the Code of Criminal Procedure here in Texas to specifically prevent judges from issuing bench warrants when the person did not appear on the citation. The person now must have a communication directly from the court that they are required to respond to, or the judge cannot issue a warrant for their failure to comply with it. Now, that's the way it should have always been.
Right.
But it wasn't till we started banging on that door and kicking it in and saying, you can't do this. And they finally wised up and changed the Code of Criminal Procedure to reflect that.
So they send you a certified letter now, or how's it? And is it just, this is just Texas, right?
Well, it depends on, that depends on how you define certified. Texas law is also very slippery in the fact that it says that simply stating that the notice was mailed is sufficient. The state's not required to prove that it was mailed. But that would be a violation of due process in relation to service because they can't prove the other party was ever served.
Sure would.
So regardless of what the Code of Criminal Procedure says about the state doesn't have to prove it, if you allege that you never received the notice, they're stuck. Legally speaking, they're stuck. Because now they can say, well, we sent it to this address. Well, that's the wrong address. And speaking of wrong address, that's another habit the Texas courts have of doing in these cases, especially in these lower courts. You get a citation, they file it with this court, and it doesn't matter what address the citation has on it, and it doesn't matter what information that was filed in the report with the citation as far as what your proper address is. The lower courts will intentionally go look up your record, find an old address that your license used to be issued to, and mail everything from that point forward to that old address, knowing you will not get it. Then they will issue a bench warrant for you not appearing on the date and time that they put in that notice that they're not required to prove they ever mailed you in the first place. They can just say they did it, and now you're the one that would be stuck if it weren't for the fact that it violates due process. But we've caught them doing that intentionally, and we used their own citation and police report to prove that the court clerks intentionally sent the stuff to the wrong address. And we got that case thrown out.
Yeah, I was wondering if that was something they did intentionally so they could just issue the bench warrant or the workaround that the legislator put in place so they could, have plausible deniability.
Well, there's another $50 in fines and extra court costs associated with the issuance of that warrant. They want that money. So they will do anything they can to make it as expensive as possible on you. And they do it for multiple reasons, most of which is to get the money in their hands, but the other of which is to make you surrender and give up before you actually have the will to fight by trying to bankrupt you.
Right. And do you have any clue about how much these big cities make off of, say, let's just say speeding tickets or
collectively, the state of Texas generates more than $9 billion a year off this scheme.
Wow.
Between registrations, license fees, renewals, insurance premiums that they get kickbacks on, and all the fines and fees they assess against people who cannot legally be charged with those offenses, it totals up to a little over $9 billion a year.
That's absolutely incredible. It's slightly less egregious than Pennsylvania's property taxes, which is a $1 trillion industry, I think Alphonse said. But I know the city of New Orleans gets $20 million from parking tickets, another 20 from red light cameras. So $40 million for the city of New Orleans. That's insane.
Yeah, I cost the city of Austin over $1.7 million in lost revenue in 3 years.
And tell us about how you did that.
I did that by helping people fight their cases.
Okay.
I helped them by going to court with them, helping them with their pleadings, instructing them on what to say and how. And we got a lot of cases dismissed. There was one young lady, she was charged with road rage when she was the victim of another guy who drove his truck over the front of her car and broke the axle on her car. And she used, despite having the broken axle, she ran him down in her car till he finally pulled over. And it was a teenage kid. And he had a bunch of teenage girls in the truck with him that as soon as he finally pulled over, they all jumped out and ran and hid in the mall while he stood there with the cops. And the cops wound up charging her for what he did to her car. Well, we took that to court to fight it. And one of the things I tell every student that I teach is when you have a court case, you make sure you monitor the court record constantly. If you've got months before trial, you monitored it, you check it at least once a week, every week without fail. Doesn't matter what day, but make sure you check the record to see if they filed anything new in that record. You do this up until a couple of weeks before trial. A couple of weeks before trial, you check it Monday, Wednesday, and Friday of the second week before. And then on the week of, you check it every single day to see if something's changed. Well, this young lady followed my advice and did that. She went down on a Friday evening before the court closed and asked to see her file. Well, when she got her file, she found that they had filed a dismissal 2 days earlier for her original case. They had secretly filed this dismissal without notifying her of it or anything else. The prosecuting attorney for the city filed it, the judge okayed it, and they dismissed the original case. The original cause number under which we had filed all of her pleadings. They had then issued a brand new complaint with a brand new cause number and set it for the same trial date of that Monday morning. So on Friday night, they had dismissed the case. She found out they had dismissed her case 2 days earlier, refiled it, never given her notice, had changed all the cause numbers, and now all of her original pleadings were worthless because they were in the wrong case.
And how'd she find out they started a new case? I mean,
because they had the new complaint and the new cause number were also in the file. Okay. They refiled it the same day they did the dismissal for the original case. They refiled the new one under a completely new cause number. And they did that to nullify her pleadings. They wanted to hide the pleadings that we had filed from the appeals court by sending it up under a different cause number. But here's the thing. In the Code of Criminal Procedure, there is no method for them to dismiss a case right before trial, file it as a new case, and then continue on to trial as if it's the same case. They can't do that. They have to start over from square one. Well, they didn't. And not only did they not start over, they didn't notify her of the dismissal. So wow. She called me and says, what do I do? I'm down here. They close in 30 minutes. They've changed the case. And I said, this is what you do. You get the court clerk to print out a copy of everything we filed in the original case. Once she prints it out, you change the cause number to the new cause number and you refile it right now. While you're doing that, I'm going to write up another motion for you real quick. And I wrote up another motion describing how we had caught the court red-handed, tampering with the record, and attempting to deny her and her right of due process, and went through all of the details of everything they had done to mess with that record and not inform her. We go to court that Monday morning. We walk in. We're standing there at the back. They call her name, and she says, I'm here. And he goes, come up here and get your dismissal. We refiled everything. We put in a motion telling them we had caught them red-handed doing it, and they knew they had no choice but to dismiss that case or they were screwed.
Now, let me ask you, does the clerk charge her to file into her case?
No.
Okay. Because here in Louisiana, this is crazy.
They can't charge you to file in a criminal case. If you're filing pleadings in a criminal case for your own defense, they can't charge you for that.
Well, that's, yeah. Okay. That's what I was checking, though, because over here it's very crazy. But anyway,
are they criminal in Louisiana or are they civil?
It's happened in both of them. The most recent one was a civil case, of course, but he was the defendant in the civil case, and they're charging him.
They can't do that.
They're charging you like $600 to file a motion. $600 to file a motion.
Yeah, they can't do that. There's something seriously wrong with that process.
I agree. Anyway, so let's just say, so you get the ticket on the side of the road. Do you do any public records requests first, or how do you go about getting all that information from the court, or do you just start filing motions?
We do several things. When you get to studying the laws here in Texas, you find out real quick that the transportation code relates to a profession or occupation which most people who get tickets aren't engaged in. And so it didn't apply to them to begin with. Well, in the administrative code, there's a set of statutes that specifically shows how a municipal or county deputy, a municipal police officer or a county deputy, gets authorized to enforce the transportation code. Here in Texas, that authority to enforce that code is not automatic. That authority has to be delegated to the local municipalities or counties from the Texas Department of Public Safety, who under our transportation code is the department that has primary jurisdiction over traffic enforcement. So they have to specifically delegate that authority through specific means called a memorandum of understanding, which they can only issue to a municipality or a county whose officers have gone through the proper certification process training with the Department of Public Safety. Well, here in Texas, there are only 67 officers in non-DPS departments that are certified to enforce traffic. Only 67. Yet every Tom, Dick, and Harry sheriff's deputy and municipal cop thinks they have the authority to enforce it, and they don't. So the first thing, we filed a public information request asking for the Department of Public Safety keeps those officers in an Excel spreadsheet. Every person it's certified to enforce the traffic laws, it keeps in an Excel spreadsheet. Who they are, who they're with, when they got certified, what they're certified to do, because there's different things they can do, such as commercial motor vehicle inspections versus traffic enforcement and safety inspections and accident investigations. They have to be individually certified to do any of these particular things. And that memorandum of understanding between them and either the county commissioner's court as the department over the sheriff's department, or for the municipality as the head over the municipal police department, that memorandum of understanding is between the Department of Public Safety and that head agency, the municipality or the county. And if that officer's not in there, they don't have the legal authority to enforce the transportation code.
So why is the state of Texas allowing all these people to write tickets then? Or is it just a money game?
Because it's up, the way they've done it is the state doesn't have to prove the officer has the authority. You have to prove he doesn't. And most people don't know that they have to go through that process, because they've written the transportation code in a misleading way. Chapter 543 of the transportation code, where most traffic offenses are written, which is under subtitle C, rules of the road. 543.001 reads, any peace officer may arrest without warrant any person found committing a violation of this subtitle. Well, that any peace officer is being interpreted by everybody as meaning anybody that is listed as a police officer under 2.12 of the Code of Criminal Procedure, which gives an entire list of legal individuals in different types of entities that are authorized to be peace officers in the state of Texas. So everybody is assuming that 543.001, when it says any peace officer, is talking about anyone in that list. But there's a problem with that hurried interpretation. Everywhere that the Texas legislature intended for peace officer to mean one of the people listed in 2.12, the legislature specifically said that. Peace officer has the meaning assigned by Article 2.12 of the Texas Code of Criminal Procedure. In every instance where they want you to know that that list of people is who we're talking about, that's how they've done it. That does not exist in 543. So I went to looking to see how the law defines the term any. And it turns out that there's a very interesting meaning out of several that are assigned to the term any. And one of them is as established by law, and a subclass within a class. Okay? So any can mean part of rather than the whole thing. Well, when you read all of the provisions of the transportation code, all the authority to enforce that particular chapter is given to officers of the department. Well, in the transportation code, the department under all of those particular chapters is defined as the Texas Department of Public Safety, the DPS. They are the officers of the department that are given the authority to enforce driver's license laws, motor vehicle inspection laws, registration laws, insurance. Okay. They're the only agency given direct authority to enforce within those chapters. And everywhere it says officer, it either is officer of the department or it says the department. So right there, that tells you that any up there is only talking about a subset of law enforcement, specifically the Texas Department of Public Safety. Now, this is an argument that no one has made in court yet, because I'm the only one that's written it up, and I'm the only one that's used it or will use it, because this can't get messed up. If you don't know exactly how these dots are connected, you will screw it up. They will rule against you. And now people that know what it is and what it means have a much harder hill to climb to win their case, because you messed it up and set bad precedent.
Right.
So, but when you look at this and you put all these dots together, it's very clear that not everybody with a badge has the authority to enforce the transportation code. And any doesn't mean all.
So the first thing you would do is get that list, right, and see if your officer's name on it, and if not,
right,
then we can make motions to dismiss. And when you do so, or do you do so in writing, or you go into court?
We do everything in writing. That is my primary rule of going to court. Everything is done in writing. Even your objections to what the court does are submitted in writing. Why? Number one, most of the cases are in courts of no record. So the only record that exists is the court file. And the court file only contains whatever somebody files into it. So we file everything to make a record for the purpose of appeal to show that this trial court is not complying with the law. So we do everything in writing. If we make an objection, we reduce that objection to writing after the fact, and we submit it in writing, file stamped with the court to go in the court record.
Gotcha. And so, and what public records requests, if any, do you do before making any of these motions?
All court records in Texas are 100% public. You're free to go in there and make copies, ask to see them. Anytime the court is open for regular business, you can go in there and get them. You can also file just a standard public information request to get them.
And that's step one for you. You go do that first, right?
Well, most of the time we don't make copies of the court record except for the very first time we go, unless something new's been added. We go to see what the other side has put into the file, not what we've put in, but what they've put in.
Right.
So because they don't serve us with anything here in Texas. They'll file this crap, but they won't serve us, but we have to serve them with everything. So we go to get copies of what they file so that we know what's going on. That way we can also say that as of this date and this time, this complaint was never filed in this file. So why is the court issuing a warrant? Why is the court issuing a summons? Why is the court calling me and telling me to show up when no complaint has even been filed in this damn case? Where did the court get jurisdiction to initiate an action that doesn't exist?
Right. Right.
And so we document that by showing that they're taking actions that are procedurally incorrect because they are out of sequence. The court lacks jurisdiction to summon you to court when there's no issue involving you before the court.
Gotcha.
Until that complaint is filed, there is no issue.
Gotcha. And so basically you put together a motion to dismiss. Anything else standard before
we put in a motion to set aside. Here in Texas, the first thing you want to do is to get the complaint quashed. And here the complaint is a motion to set aside the complaint. And in that motion to set aside, once we move to have it set aside, once they have no complaint, jurisdiction is lost. Therefore, we subsequently ask that the case be dismissed. So we do that within one motion, but here it's called a motion to set aside.
Gotcha. And so you you gather your information, you see what the court's done wrong, you submit it in the motion form, and it's court day. What happens now?
Well, the first thing here, well, you want to know what happens, or you want to know what procedurally is required to happen, because they are two very different things.
Well, you can go through both really, because we just want to know, what we need to do when we go into that court. Are we appearing as a special appearance, or you don't use that
Well,
tactic?
all of your pleadings should be filed in propria persona, in your
Okay.
proper person. Okay, it's not filed pro se. It's not filed any sui juris or any of that other crap.
Now, is that
In
a
propria
distinction in
persona.
Texas from other places, or
No.
pro se is
If
very different than
if your
impropriety?
intention, yeah, pro se is very different. Okay, pro se is you're acting as your own counsel. In propria persona is I'm appearing in my proper person, not your legal person.
Gotcha.
Okay, everything in this document's dealing with a legal juristic person, and I'm not that person. I'm appearing in my proper capacity. Okay, you're trying to use a law against me that I don't belong to the class of people to whom it applies. That's a misapplication of law. Therefore, it would be a misapplication of terms to call myself a pro se, because a pro se would be someone that is subject to the laws that are being argued over and the offense that those laws are calling you to court to reconcile with. So they're very different things. If you look them up, the Latin meaning is very different.
Okay, and have you witnessed any event where that language helped or hurt you?
On appeal, it does. It isn't going to do a damn thing in the trial court. Here in Texas, the lower courts, we have justice of the peace and municipal courts that try traffic cases. They are the courts of exclusive original jurisdiction for Class C fine onlys involving traffic. Okay. The problem is that nobody follows the Code of Criminal Procedure and the Constitution and how they do it. Nobody.
Right.
Even where the Code of Criminal Procedure says they must do these things, they don't do them ever. And right there, we have a violation of substantive due process when that happens. So what we do is, procedurally, if we go by the Code of Criminal Procedure, what is supposed to happen is, 1, a complaint gets filed. Nothing happens until an actual complaint is filed. The citation can do nothing. There can't be warrants issued. There can't be any of that crap unless it's for something else. But as far as what our procedure says, the first thing that must be filed to motivate the process is a complaint. That complaint, if it's made to a district or county attorney, the district or county attorney is then required to reduce that complaint to writing, get it signed by the affiant, then they generate an information based upon that complaint and they sign that. Then they put those two documents together and they send it to the clerk of a court that has of the district court, basically, according to the Code of Criminal Procedure. The district court, even for a Class C fine only, according to the Constitution and the Code of Criminal Procedure, is then required to take that information and complaint and forward it to the grand jury. The grand jury then must true bill and hand it back down to the district court, who then sends it to the court having proper jurisdiction to try the offense. Well, here in Texas, despite that being the process written into law, it's completely ignored. Okay? Because guess what is supposed to happen, even in that procedure, in between the complaint being filed either in front of a judge or in front of a county or a district attorney. Once that's been done, the complaint is filed. The procedure here, according to Chapter 16, is that a magistrate must convene an examining trial to look into the allegation to see whether or not probable cause actually exists to proceed to an actual trial.
Now, Eddie, this would take up way too much government resources, and they're just, who would even sign the complaint on a regular traffic stop if they put a complaint in the file? Who would sign?
Well, that brings us to another problem. Right now, the cop would normally anyone in Texas can sign a complaint. You don't have to be a witness. You don't have to have firsthand knowledge. Anyone can sign a complaint in the state of Texas.
Oh.
Except for the prosecutor's office or the judge who's hearing the case. And here in Texas right now, the process they're using is they're allowing the court clerks to initiate the complaints and to verify each other in the making of the complaint. One court clerk will be who the oath is administered by. Another court clerk will be writing the complaint and swearing it as the affiant based upon the citation written by the officer. But now notice that the citation itself is not a verified statement. It's not a sworn to statement. It's just a set of notes made by the officer, and this court clerk is taking it as gospel and turning it into a complaint. Yet there's nothing on that that says that that's a sworn statement by the officer upon which these facts are true and correct.
And they do this in most
They
cases?
do this every single day in every single case.
Wow.
Okay. Due process in Texas is truly a tool of the just us system. And it ain't talking about we the people. But in any case, the two clerks, they cross-check each other, the complaint gets filed, and then they go proceed directly to trial based upon that. The problem is that a complaint in the state of Texas, under the Constitution and the Code of Criminal Procedure, cannot invest a court with jurisdiction. The state constitution specifically says that an indictment or information is what invests a court with jurisdiction of the cause, never a complaint, because a complaint is nothing more than an allegation. Legally speaking, a complaint is only good for the issuance of a warrant to bring you before that examining trial magistrate to check to see whether or not probable cause exists based upon the allegations, to then either confine you to jail, release you on bond, and proceed to an actual trial after they get an indictment, if they get an indictment. Okay? See, the Texas Constitution used to specifically state in the Bill of Rights, Article 1, Section 10, that no person could be prosecuted for a criminal offense except upon indictment of a grand jury. Well, they changed that after the Civil War in the 1869 version of the Constitution. They added a little paragraph to the end of it that made it where, except in the cases of fine-only offenses or where incarceration in a state prison facility is not a part of the judgment, okay? So basically, if they're not sending you to a state prison, then they don't need a grand jury to indict you. But here's the problem. Article 1, Section 29 of the Texas Constitution and the appendix to the Texas Constitution. The appendix specifically says that they cannot amend any part of the Texas Constitution to adversely affect a vested right. Now, to me, my understanding of a vested right after reading the definition of it is something that I have a right and a claim to at all times forever. Okay? And once a right has been memorialized, so to speak, in the Bill of Rights for the Constitution of our state, Article 1, Section 29 says that once it's in the Bill of Rights, it is forever removed from the power of government. Okay? That means it can't be taken out again, nor can it be diminished in any way by an amendment to the Constitution. So they amended it to take one part of that Article 1, Section 10 out about the requirement for an indictment by altering it and downgrading it to except in these cases. Well, unfortunately for them, that's the changing of a vested right through constitutional amendment, which runs into a problem. Okay? Because that means you ask the people to vote to take away my right to something, and they have no right to vote on that. And the Constitution itself forbids them the right to vote on that once it's in that Bill of Rights pursuant Article 1, Section 29.
Yeah, it sounds like Texas's version of the Supremacy Clause.
Exactly.
Exactly.
But everything they do here in the state, they're completely ignoring the Constitution and the rules of procedure to get it done. And they're doing it for judicial expediency, to cut their costs, increase their profits, and to get it as high a turnover on clientele and customers as absolutely possible.
Yeah, and that's what corporations do. I mean, they have to get money for their shareholders, right?
Well, they're public corporations, but they don't have shareholders. Right. But what they do have is investment accounts.
Mm-hmm.
And they can't put money in those investment accounts if they can't steal it from us.
Right.
So there's their financial motivation.
Yeah. Yeah, they
Now,
definitely just a big shell game. Just a big shell game.
well, do you want to hear what that shell
Yes.
game
Yes,
proves it to
please.
be a criminal enterprise? All right. What do you call it when a business takes a bunch of money, whether it's through theft, fraud, extortion, straight up robbery, any way they get their money? And they take that money and they wash it through all these other types of legitimate business processes so that their money gets clean. What is that process called?
I think the mob refers to it as money laundering.
Bingo. Now, let me describe the monetary process in Texas. These cops issue these bogus citations, which at a minimum generally average about $200 per. Okay? And that's for each charge. That money is then collected at the court level by the municipal or justice courts by finding you guilty. That money is then put into an account that gets divvied up between the local entity, whether it be the county or the municipality, and the state. The state gets 50% of the fine, and the municipality or county gets the other 50% of the fine plus their costs that they've added to it, their court costs, their other fees, and all that other crap. Okay? So that's the division of the money. Well, Texas law specifically says that all money collected by these counties or municipalities or the state itself are required to go into a specific fund, the Road and Bridge Fund, okay? So that they can maintain roads and bridges using these fines and fees they collect from people. So that goes into that account. But where does the money come from to pay all these judges and prosecutors to pursue these people to get that money in the first place? Well, it comes from a separate account, they tell us. Okay? Well, where does the money for that come from? Well, that money is allocated from the pool of money that the city has access to when they divvy up their budget, right? Well, how much money from that budget is being freed from going into the Road and Bridge Fund by taking the fines and fees these judges steal through their bogus decisions to go into that fund? So all the money that's taken from us to go into that fund no longer has to be allocated from the resource pool the city starts out with. It gets to budget that somewhere else. In other words, they took their dirty money, they stuck it in that account, and they took their money from other accounts and passed that over to the judges, and that's how they get paid. That's fucking money laundering, dude. That is money laundering.
Nothing like the judge directly benefiting from the sentence he gives you.
Exactly.
Yeah.
And so when they say, well, it's not a conflict of interest and it's not unfair because they don't get that money directly. So what? That money is being used to offset other monies that they do get directly. How is that not money laundering?
Yeah, I mean it's like Alphonse said in Pennsylvania. It's the property tax is a RICO. It's federal racketeering. Tax is
a RICO everywhere.
Yeah,
it's a RICO everywhere.
Unbelievable.
But here in Texas, there's a way to prove that it's absolutely illegal. Just no one's bothered to do it yet. And I don't know why. If we've got all these smart real estate attorneys and property law attorneys, why they haven't done this and made this a thing, I don't know. But to my knowledge, not a single person has filed this in the state of Texas for property taxes.
Well, they'd have to go back to income tax if something happened to the property tax,
Texas
right?
has never had an income tax.
Right.
Texas the Texas Constitution says they can't implement an income tax here.
So does the U.S. federal Constitution, but you
Right.
know they do.
Well, that's the thing. Well, once again, that's depending upon what you're told to believe the law says versus what the law does say.
Right.
My good friend Dave Champion wrote a book called Income Tax Shattering the Myths, and he
We-
goes through all of the federal laws, all the federal court cases, everything.
We've
proves
had him on. We've had him
Yeah.
on.
Yeah, Dave.
Yeah,
Dave is.
It's a great book. It's I will tell you that Merlin says he left a few things out, but nonetheless, it's a
Yeah.
pretty good book to give you an overall view of what's really going on for sure. And so okay, so we go through this. We they don't have the grand jury indictment. They don't have
The
whatever
examining trial.
right. They don't have all these things, and they're trying to drag you into court. They don't dismiss your motion. They don't grant your motion to dismiss, and you have to go to.
They don't even read them. They just dismiss them out of hand, and
Right.
that's okay.
Right.
At the trial level, that's what I tell people. You are not going to trial to win. If you think you're going in there to win, you are sadly mistaken. It is only in the most egregious of circumstances that you can hem them up with that you're going to win. Like what they did with this girl's case for the road rage crap, and we caught them tampering with the record.
Right. Right.
That they couldn't get out of. There was no way in hell for them to get out of that. And if they move forward, everybody was not only going to lose their job, somebody was going to jail.
As many of them should.
Yes. And so they dropped that like it was a nuclear byproduct.
All right.
They didn't want it.
And we're here at court day. You're walking into court, and what do you appear as a special appearance, or you don't worry about that language?
Yes. We do. Okay, there's case law that specifically tells you how to perform a special appearance. And the first thing to remember about a special appearance is you can never, ever open your mouth without first stating that everything that you're about to say and do is relative to a special appearance. The case law is very clear on that. If you say or do anything dealing with the merits or the procedure without first reserving your right under special appearance is waived, personal jurisdiction exists, and now you're stuck with subject matter only if you can prove it.
So we're a word game and shell game again in the courtroom.
Exactly. This is why they tell you that you really need a lawyer, because if you don't understand all these little nuances they've embedded in the system, they've got you and they know it.
And if you hire a lawyer, you're automatically not special appearance.
Correct.
You're going to defend the case, and you're
going on the merits no matter what.
And they have
so
subject
they've
matter.
They've developed a really good catch-22 for this.
Yeah. And so what do you say as special appearance? How do you fight this or get your guilty and move on, or what transpires here now?
Well, again, it depends on whether or not we're in a court of record or a court of no record.
Well, I'm assuming in a traffic ticket we're in a court of no record.
Well, assume away. But if you're in one of the big cities, that's likely to not be the case.
Okay.
It will be a municipal court of record.
Okay.
Now, if you're in a justice court, there is no justice courts of record anywhere in Texas. But municipal courts, the larger municipalities, are generally municipal courts of record.
Interesting. Okay.
Okay. The smaller towns, however, almost never are.
Right.
So the first order of business when you start filing documents is to find out which kind of court you're in, because it makes a difference. But in any case, yes, the first thing out of our mouth is I'm here by special appearance to challenge the personal and subject matter jurisdiction of the court. And then I would like to ask the court if the court has read our pleadings. Yes, the court has read your pleadings. Question, Judge. You stated you read my pleadings, including the part where I accused you of screwing the neighbor's dog every Friday night for the last 3 years. Did you read that part?
Nope.
I don't think I recall seeing that. Well, you might want to go read it again. Okay? If you didn't see that, then you might want to read it. And if you want to tell me that I'm wrong, then you've got to rebut that in some way, shape, or fashion. But while we're on the subject of you screwing the dog, did you also read the part where I accused you and the prosecutor of colluding to railroad people through this court, and I put that in there for you? No, I didn't see that either. Oh, So what you're telling me then is that you're lying to my face and you did not actually read the pleadings. You're denying them out of hand without any recourse for me and my right of due process. You've also not required the prosecuting attorney to respond to any of those pleadings point by point so as to rebut them, so that I have a record for the purpose of appeal to show what legal basis you and he are going to use to say, I don't know what I'm talking about. Is that the case we have here? Yeah, that about sums it up. Okay, then I move for your immediate recusal. Well, I'm not going to recuse myself. Fine. Then I immediately move for your disqualification under Chapter 29 of the Texas Government Code. Now, if this is a municipal court, he has no choice right then but to stop. Chapter 29 is very, very specific. Once jurisdiction is challenged in a municipal court and a dismissal of the judge has been requested, all proceedings must cease, and the case must be forwarded to a head administrative judge of the district to determine whether or not the dismissal is required or the disqualification is required, and go from there. So at the very least, we're costing them money by delaying them.
Yeah.
Now, even though Chapter 29 does not specifically deal with justice courts, I've got case law that says, procedurally speaking, justice courts are no different than municipal courts. Therefore, if there's a requirement for the municipal court, then that requirement would apply equally to the justice court. So Chapter 29 can be used against the justice courts as well. But
okay.
Once they go on the basically, though it's not a court of record, when I say we put everything in writing, we also reduce to writing sworn affidavits of what the judge said and did that day in court. That we informed them they were disqualified, that we asked them to recuse themselves, they refused, they declined, et cetera, et cetera. Now, technically, the judges in Texas can't rule on their own disqualification. They can rule on their own recusal, but they can't rule on their own disqualification. And Chapter 29 codifies that requirement. So once that's done, we send it up in writing along with everything that we have about what that judge did in affidavit form, and we send it to the head administrative judge. Now, usually what happens is they will then assign a different judge to it, and we'll start this process again. And we'll go through the same rigmarole with every single judge they put in there until they either do it right or they railroad us through, and then we take it up on appeal. But we do everything in writing specifically for the purpose of making a record for appeal. But even here, that has its own catch-22 problem. If you are at trial in a court of no record, then your appeal is to a court of record de novo, which means it's a complete do-over. It's a mulligan, which means that the new appeals court isn't really an appeal. It's a brand new trial. And because it's a brand new trial, they don't look at any of the egregious crap the court beneath them that got us here ever did. So there is no direct way for a higher judge to be used to hold that lower judge accountable for ignoring the law, violating rights, ignoring the rules of procedure, nothing. There's no way to hold them accountable because everything's ignored when you go to that trial de novo. But that's the difference between the courts of no record and the courts of record. In the courts of record, they can't do that without being caught unless they tamper with the record before it's sent up. So those are the things we're looking for. Those are the things we document, and those are the stones we use to beat them black and blue with. And so far, we've been pretty successful with it. We don't win every case, but we win more than we lose.
Yeah, it sounds like it, and it does sound like from you and some others that I know in Texas that they're much more responsive to when you call them out for breaking the law or not following procedures, whereas some of these other states they have no regard. Doesn't matter.
Oh yeah, California is notoriously bad about it.
Yes,
and as is Louisiana.
Wow, we're a whole different subject over here. But
well, I used to be stationed at Barksdale over in Louisiana, working in the 917 Fighter Wing over there on A-10s.
Okay.
And I had to go from Nacogdoches to Louisiana on a regular basis for duty.
Yeah.
And so I got pulled over all the time, but not once did I ever get a ticket. I managed to look at the cop, and he'd tell me why he pulled me over, and says, well, then how did you get to here from this, 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 and this? Because at that time, I was very familiar with Louisiana law like I am with Texas law. And so it's kind of like, well, you're kind of missing a few steps here, sir. Do you realize that, right? And if we go to court, I'm going to make damn sure this gets brought up. And they're like, they'll think about it for a minute. You just be safe, and they'll get back in their car and they'll leave.
If you're lucky.
Well, so far I was. All the time I was there, I was.
You know, I absolutely love the A10. I know all about it, and it's a phenomenal airplane. I'd love to chat with you about that. This is not the appropriate forum, but I do love the A10. It is an awesome plane. So we went through the, on the side of the road. Don't try your case on the side of the road. It's dangerous with the cop. Just shut up, take your ticket, go to, and then do public records requests, find out what's in the court record, and then put it in your motion to dismiss, and anything else that the court has done wrong, file that, go into court, special appearance, test the judge, make sure even though he said he read it, make sure he really did read it. Yep. And when he didn't, which he definitely did not, then call him out on that, and then ask him to recuse himself, and then to disqualify himself, and then that gets you into a new judge. Rinse, repeat until you find an adult in the room.
Right. Now let's go back to the traffic stop for a minute.
Okay.
There are some very important rules to remember about traffic stops. First and foremost, the 3-step rule. Number 1, shut up. Number 2, when you've complied with number 1, shut the hell up some more. Number 3, when 1 and 2 are fully done, still shut the hell up. Okay? Second rule, when you are speaking, your speaking is meant to do one of 3 things, and one of 3 things only. Invoke a right, demand a right, protect a right. If you are saying anything that is not doing one of those 3 things, you are saying too much. Now, if the law requires you to give them certain types of information, give them only the information required by law in the simplest manner you possibly can. Do not elaborate on anything. Do not respond to any inquiries beyond that information. Do not expand your explanation or answer to anything. Everything is straightforward, to the point, and only what you are asked, and only if it is something you're required to give. Name, address, and date of birth, for instance. Otherwise, shut up. This cop is not your friend, no matter how nice they're being. Everything they say to you is meant to get you to admit to something or say something that will either A, give them the evidence they need to charge you, or B, give them a hook they can use to follow that line back to you and reel you in for something else.
Yep.
Because what you have to understand about the training these cops get, every single traffic stop, no matter what the original premise, every single traffic stop is designed to end in one of 2 things: a DUI or a drug bust. That's it. Every single stop. They don't give a shit you're 5 miles an hour over the speed limit. They don't care. They went 40 miles an hour over the speed limit to catch up with you. They don't care. That's not the point. They now have an excuse to pull you over to try and tug on a thread that will get them to that DUI or drug bust. Every time.
And what is the underlying rule about pulling someone over for one of these traffic citations that are not in commerce?
Well, clarify your question for me.
So if, you're speeding and you're just driving along, you're not having anyone for hire, you're not transporting any goods, you're not in commerce, then how are they getting the authority to pull people over that aren't in commerce?
Well, depending upon how the law is written, that's an interpretation they don't have. You may know it, but that's not necessarily an indication they know.
Right.
Okay. The laws are intentionally written to deceive, okay, until you learn how to read them. Once you learn how to read them and how to connect them together, see, there's this little rule in law called in para materia, okay? That means things of like kind or same subject or same class, okay? So when a statute deals with something on the same subject as another statute that deals with that subject, those statutes have to be read in para materia together as if they're one, okay? And there may be more than 2 statutes. There may be 100 different statutes that deal with that subject, and all of them will have some bearing on what that subject must be interpreted as, how it must be applied, and how it must be understood to operate, okay? Once you have all those collected and you understand that bigger picture that focuses down on this and all the angles it's got to come from, then you have more ways to attack their interpretation and application of that law. It is not one, there's not one statute in any state that will give you what you need to specifically say that law does not apply to me. It is this myriad of statutes related to that subject that when you read them as a whole, make it very, very clear this cannot possibly be talking about you. Because all these things put together draw a completely different picture than the one you're trying to force me to look at.
Exactly. And yeah, so, and for those, you know, that following along, I haven't heard the para material together, but ejudum generis or whatever, but they're all rules generis. All rules of statutory construction. If anyone is interested in looking that up and learning how to read the law, we have a lot of those posted.
Yeah, ejudum generis is usually used when trying to interpret the meaning of words like includes or including.
Gotcha.
I've got an article about that on my legal blog, which is taooflaw.com with hyphens between the Tao and the of law. But taooflaw.com, I've got 2 articles on there about includes and including. And I go into a very plain explanation of how any statute that uses those terms has to be read to operate properly.
Right.
And that's where you'll find the most discussion about the rule of ejudum generis.
Right.
And that is things of like kind. Not the same subject, but things of like kind. And so when includes or including is followed by a list of things, then there has to be some common denominator relationship that exists between those things before the use of includes or including is valid.
Right. So you can't have a bunny, an airplane, and a frog.
It depends. Is the word stuffed in there? Or is the word toy in there?
Oh, well, no. But what my point is, if you have a list of animals and you add an airplane to it, that's just not going to work.
Right. If the presumption is these are supposed to be live animals, you are correct.
Yeah.
But if the previous up to and including any toy, including rabbits, airplanes, dogs, blah, 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 now you've got a whole different meaning.
Yeah, we have to apply some common sense.
Yes. But now you know for sure the class of things are listed to toys.
Right.
Okay. So using includes and including in statutes, you really, really have to understand how those terms operate, or you will never, ever have a proper understanding and interpretation of a statute you're reading.
Very, very tricky and deceitful, these laws are. So if you, we're an hour in, if you have a little more time, I'd like to discuss the differences in the traffic versus the criminal, if you want, cases.
Sure.
And if you would be so kind as to go into a brief example of the criminal code. And
well, here in Texas, traffic is criminal. All traffic offenses in Texas are criminal.
Right.
But
they're handled a little bit differently, right?
Yeah, they have 2 separate sets of rules. They have the regular code of criminal procedure, and then they have a subset of rules within the criminal procedure, chapter 45 and soon to be chapter 45A, that deals with specific class C fine only offenses, not just traffic, but any class C fine only case in a justice or municipal court. The one thing about those chapters, though, for that specific subset is that it tells you very clearly that if that subset of rules does not deal with something that the other set of rules does, then the other set of rules, the bigger set of rules is actually controlling in that particular aspect. That's something else they don't do here. If it's not in this subset of rules, they don't care. They're going to do it how they want, regardless of what the bigger set of rules says they're required to do. And that's part of the problem. Our highest criminal court in the state of Texas has knowingly and willfully violated law to create a set of rules of procedure that violate that law. So what they do in practice is in direct violation of the rules governing the practice they're required to follow. And that's what Randy's lawsuit was all about. The problem is, it was Randy's lawsuit. So what I'm doing now is I am rewriting his lawsuit to actually be pertinent. And we're going to use it to go after all these judges that are ignoring the law and ruling against people without providing due process. And we're going to do the exact same thing Randy was talking about in showing here are all the things the Code of Criminal Procedure requires. Here's why all the case law saying they don't have to do this is bad. And here is why every case involving this is invalid and needs to be reheard, which is trillions of freaking dollars if that ever comes to light.
Right. No, of course. But I mean, as we've seen, Erlin for sure has taken, several tax cases through to the appellate courts, and several appellate courts rule in direct contradiction to what the SCOTUS says, because they're protecting the money here.
Yeah,
The status quo.
The status quo.
I mean, do you want to be the judge that says there's no more property taxes in America and what the ramifications that is? I think that's a pretty heavy burden.
Well, the thing is, they misunderstand the burden. Would you rather be the judge that says we've been doing it wrong, or would you rather be the judge that says piss on the Supreme Court and wind up getting your bar card yanked so you can never practice law again?
Well, we haven't seen much of that happen.
No, we haven't, and we need to.
Yeah, agreed.
But the thing is these judges think that they're impervious, but they're not. Remember that the federal Constitution says these judges hold their office only so long as they are in good behavior. When their behavior violates existing law or the Constitution, they're removable. They can be impeached and they can be removed from office.
Yeah. With let's see, the that Congress up there. If we're talking about federal judges, of course, can you imagine an impeachment vote going through and then the Senate holding a trial?
No, not with the morons we have.
No, that's just not possible.
But I, for one, would think, that at this point, burning down all of Washington, D.C. while it's fully occupied would not be a bad thing for this country.
Well, there's an old saying about when Edwin Edwards was governor here. I think he was governor 4 or 5 times. They said they sold the voting machines to Mexico when he was elected governor of Mexico. But there's an old saying, of all the lawyers and Edwin Edwards were in a boat and they were sinking in the middle of the ocean, who would be saved? And the answer would be Louisiana, of course. But
it's also kind of like that joke: a busload of lawyers goes off a cliff into a lake. Good thing, bad thing. How many do you save?
Yeah, one is the example. You save one as the example of what not to do. But anyway, getting back to your criminal stuff. So you pretty much go through the same procedures here, right? That you did in the traffic case, right? Public records, all the body cam footage, stuff of that nature. Look for discrepancies. Write a motion to dismiss, and any other things that you see that are egregious, of course. But they probably do go to grand juries for these things, right? Or no?
Yes, most of them, unless, like I say, unless they don't involve incarceration in a state penitentiary, they do.
Okay.
But again, the process is supposed to be the same regardless of the level of the offense. They're still required to have the examining trial. They're still required to have the grand jury indictment. They're required to have all of those things. They just don't do them because they're inconvenient to them instead of to us. But rather than protect our rights, like I say, they're after their conviction rates and their money so they can seek higher office and more of it. That's what it's all about. But I don't know. The process for this stuff Have you ever read our Texas Constitution?
I've read some of it, only because I was referencing some of Randy's
Right.
lawsuit when I read it. He is a little bit long-winded when
Yes,
writing.
and a little bit off track. He tends to wander a bit.
He does wander a little bit, but he does know his stuff.
Yes. He and I had a discussion the other day about how, procedurally speaking, his lawsuit shows that he's guilty of the same problems that the courts themselves are guilty of. He was laying out the process as he understood it. But the way he understood it, I would taught this in my class before last. And we were going through it, and I was saying, okay, here's Randy's lawsuit. Here's what he says they're doing wrong. And then here's the actual statute. Well, when you read the actual statute, Randy is still laying out the process incorrectly, just like they are. He's laying it out a different way of incorrectly, but it's still incorrect. For instance, in his lawsuit, he says that the prosecuting attorney or the magistrate is required to send a complaint to the judge of the examining court, and the judge of the examining court is then required to send it to the court having jurisdiction to try the case. Well, that's not what it says. It does say that in one part, which is the general section, but in the detail section, it specifically says that he must send that package to a court clerk of either a district court or a county court. It's not sent to the court, it's sent to the court clerk. And the court clerk is then required to forward it to a grand jury.
Gotcha.
So it's not the magistrate that gets his hands on it, which is what Randy was saying was supposed to happen. It's the court clerks who get their hands on it and what their duty under the law is to do with it. But in every case, whether it's a county or district court, they're required to send it to the grand jury. The grand jury must then look into it, true bill it, or no bill it. Only then can they get the trial.
Just goes to show you, kids, that no matter how long you've been doing this, there's always something to learn.
Yeah.
For sure. Is there anything else of importance we need to cover?
Well, not unless you've got some specific questions you want to ask.
Well, how did you get to reading all the code and the statutes and getting involved in all this?
Well, believe it or not, originally I got involved in this because of property taxes.
Okay.
The county tax assessor was trying to steal my mom's house and her land by assessing her an egregious property tax that was completely out of line with everybody else's property taxes. So I pulled up the tax code and I started reading it and I started looking at all of it. And I found out that the way they were assessing a property for taxes was illegal. The county assessor was just making up numbers out of thin air. The law specifically requires that for them to assess a property, they must, 1, personally inspect the property. 2, they must inspect the inside and exterior of all buildings on said property. Well, they can't enter your home to inspect it for tax purposes without a warrant, can they?
Nope.
They can't get a warrant unless there's an actual crime suspected to have occurred, correct?
Yep.
So there is no way for them to comply on private property with the tax code on how an assessment is required to be made, right?
Not unless you're willing to grant them access.
Right. So therefore, an assessment on property that you cannot properly evaluate is patently and facially unlawful according to statute. So I took that, I wrote it up in a little statement, and I went to see the county tax assessor. And I said, let's talk about what you're doing. Please explain to me how you arrived at these numbers. And I recorded this whole conversation. And he told me how he would be looking at the reports on property and values and sale prices and all this kind of stuff. And I was going, can you do me a favor and show me where the statute authorizes you to use that information to assess the property tax? Well, no, that's just how we do it. Yeah, but can you show me where the law says that's how you can do it? Well, no. Well, then how about you take a look at this part that says how it's required to be done? And I showed him the statute. Well, we don't do that. No shit, Sherlock. Hence my point and the reason I'm in your face. So here's what's going to happen. You're going to change this assessment and you're going to do it according to law. And if you don't, I'm going to take my tape of this conversation. I'm going to take the copies of this statute and I am going to have you criminally prosecuted for freaking fraud. And I'm going to make sure to name every commissioner's court judge in there with you as being your direct supervising entity and having no care about how you do things. Let's have that conversation. 2 weeks later, they sent my mom a notice saying that her property taxes were no longer required and that they were removing her from the tax roll. They didn't send her, at least while she was alive, they never sent her another property tax assessment.
Wow. You were far more successful than many others.
Yeah, well, the thing is, I still learned that there's an even more permanent and easier way to do it by suing them specifically. See, here in Texas, all private property was assigned through a land patent. And the land patent was issued by the state and signed by the governor when it was issued to the new property owner. And those land patents in the state of Texas specifically say that the state of Texas relinquishes all rights and claims to said property forever. Now, I've got reams of case law that says that just like any agreement with the government, if the government is going to reserve specific rights to itself relative to property or methods of governmental operation or whatever, like a city charter, for example, the entity issuing that charter or that agreement must reserve those rights in the terms of that agreement. But the land patents here in Texas make no reservations to the state for anything, not mineral rights, not taxation rights, nothing. So if you take all the land in Texas and you plot out a map of the boundaries of those land patented territories on the shape of Texas, and then you take that plot and you overlay it with all of Texas, Texas will look like a piece of Swiss cheese because there is tons of land within its territorial borders over which the state excluded themselves from having any right whatsoever to tax or do anything to, even eminent domain.
And so these little pockets that they do have authority over are cities or what?
They're usually still state-owned property like national forests and things of that nature.
Gotcha.
State forests, I guess I should say.
And they won't be taxing anyone in a state forest.
No, they can assess property taxes for using the state forest. See, that's the land they can assess property taxes for, is the public lands. And then they can equally divide that assessed tax up between all of the people of Texas to pay. That's how it's supposed to be done, an enumerated tax. Okay? So they figure out, here's the property taxes, divide that up between everybody, and here's what they owe. And that's it. But they can't tax your property, provided that there's something that proves your property is not part of that public property they can tax. So and that's what that land patent does.
So do we think that if somehow someone was successful in these property tax lawsuits, that's how they would do it? They would say, okay, we have this much land and acreage, and we're going to charge astronomical fee per land and acreage on the state forest, and we're going to spread it out amongst the entire Texas population. You think that's how they would have to do it?
That's not the proper way to do it because, one, we don't have any say-so over how they assess the property for the state, for the public lands. And that's not our argument. Our argument is you can't tax my land.
Right.
So let's talk about my land. My land was issued under an original patent, number blah, 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 in the year of blah, 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 signed by the governor of the state of Texas, blah, blah, blah. That land patent is an agreement, a contract between the state of Texas and the original landholder. And according to its language, it is an agreement between not only the original landholder, but all of his heirs and assigns forever. So that means anybody who inherits the land has the same rights as the original owner. anyone who has sold parts of that land patent have the same rights as the original owner. And that patent is supposed to be carried forward in that new property owner's name.
Right.
That new property owner then can sue the state for breach of contract and tortious interference with the contract. And they do that in two ways. Tortious interference is assessed against the county tax assessor because he is assessing a tax the state cannot legitimately make. Thus, he is interfering with the agreement between the state and the property holder. Then we sue the state for fraud and breach of contract by taking money from those taxes the state knew it was not entitled to. So now we've got a RICO suit on top of those three things.
Yeah. And so was land patents used throughout the country, or is there some states that...
I don't know that. I know they were used in Arizona. I know that all the land patents issued in Arizona were federal land patents. Therefore, the state can never supersede them. They were issued by the federal government to the property owner. The state can no longer touch that property once it was ceded to someone by the Fed.
Gotcha. And so have you been successful getting anyone else off the tax rolls?
I haven't attempted to get anyone else off of it, but I have stated many times on my show that if somebody wants to argue property taxes, they need to be working on getting their land patent carried forward in their name so they then can use the breach of contract attack and use that.
Gotcha.
Because to me, since there is a signed agreement and that agreement is enforceable in any court, then that's the way to go. The state cannot tax a property where it did not reserve to itself the right to do so within the patent relinquishing rights and claims to that property.
And so are these land patents fairly easy to find?
The original patents, you can find them in the county records, yes. But then it becomes a matter of tracking those to the current plots of land and how they've been divided up over the years, et cetera, et cetera. The best person you can get to do that is an oil and gas landman. You want somebody that can track down the owners of an actual piece of land and find the true ownership papers, you hire yourself an oil and gas landman. They know how to do the research. They will find that patent.
Yeah,
they will find that original owner.
Yeah, they got to find the mineral rights, right? I mean,
exactly.
Yeah,
that's exactly right.
Yeah.
They cannot get on that land and take anything off of it till they know they have dealt with the true actual owner of that land. And they can find every record to back that up before they ever set foot on it.
Yeah.
So they're the guys you want to hire if you don't know how to get there yourself.
Yeah, early on there was a lot of land patent talk amongst the Patriot mythology folks, and it got confused in the shuffle. But I'm glad you and we had one other person, Benny, came on and talked a lot about that too. But there is
the difference is when they try to create a form of patent that didn't originally exist in the law of that state. Here, that's how it was always done.
Right.
That is how the state relinquished public lands for private use, was through a land patent. And we have a section in our state constitution that specifically talks about it. And it created the Texas Land Office specifically to manage and issue those patents. That office still exists. It just won't do its job. It will no longer do the constitutional duty it has to carry forward patents in the name of the new property owners when those patents are requested, which means we have to sue the Texas Land Office and Land Management Bureau as well.
Gotcha. All right. Well, I unless you have anything else to add, I think that's a good stopping point for today. And like I said, if you have anything else, that's fine. But otherwise, I want to thank you for your time that you spent with us today. And I know that we'll find it very, very enlightening and valuable moving forward, especially with all these little minor traffic issues that everyone seems to be popping up with lately.
Okay. Well, I hope so. If I can offer one thing.
Yeah.
I have class subscriptions on a monthly basis where people can subscribe to my online class, and it's done over Zoom.
Okay.
But the first Thursday class of every month is free and open to the public.
Okay.
Okay. And a lot of the people in my class post a link to that on your Telegram groups.
Okay.
So if anybody wants to come and participate in that free class, you can do so without having to buy a subscription. If you like the class and want to stay, then just let me know and I'll send you over to Rule of Law and you can get a subscription for the class.
All right, yeah. If you would email me a copy of that link, I'll
Sure.
put it in the description here, and then everyone can
Well, the
find
link
you.
changes. I specifically have the Zoom class link where the email is sent out. But what I do is I will, if you will give me, can I use your email address to send you the class, the free class link? Okay.
Of course.
Then what I'll do is I'll add you to the list where on Thursdays when I'm sending out the free class link, I'll send it out and you can use it.
Okay, yeah, and I'll try to remind people on here regularly about that. But
okay.
In the meantime, is there any other contact information you want to give out?
Nope. Just listen to our show at ruleoflawradio.com and logosradionetwork.com, and go look at my YouTube channel. Just do @Tao of Law, TAOOFLAW, and also my legal blog, TAO-OF-law.com.
Gotcha.
Or taooflaw.wordpress.com. One word.
Okay. All right. Well, thank you, Eddie, for your time today. We really appreciate it.
Yes, sir. Thank you for having me.